sure you're all aware, the maximum compensatory award for unfair dismissal broke the £100,000 barrier for the first time. That's probably not something that's going to make a high-earning city banker crack open the champagne or pop up the bunting, because of course the loss for a dismissal is likely to far exceed that sum, in part because remuneration levels are high, but also because obtaining alternative employment in the financial sector post-dismissal can be hard, if not impossible, particularly if the dismissal was for misconduct and was accompanied by a finding of an FCA conduct rule breach. According to the Ministry of Justice statistics, between 2014 and 2017, reinstatement or re-engagement orders were made in 0.03% of cases. Now, not a lot, and the statistics don't no longer record what happens in relation to re-employment orders, which might suggest that there's been no upward change. Of course, the figure is relatively meaningless in any event because the statistics never recorded whether the annual number of re-employment orders is low because they're only rarely made, or whether few applications are in fact made in the first place. And we think that re-employment orders are in fact the underused weapon in unfair dismissal cases in the financial services sector. And if made, the order requires the employer not just to reinstate or re-engage the claimant, but it also requires them to pay back pay between the date of dismissal and the date of reinstatement or re-engagement, a sum which may, of course, run into 6 and 7 figures. And if the order is not complied with, there's additional compensation on top of that. Now, applied correctly and with a proper bit of thought and sophistication, the threat of reinstatement or re-engagement is likely to give a respondent far more food for thought during negotiations than the threat of a finding of unfair dismissal and capped compensation. So in this talk, Sophia and I are going to begin by looking at the relevant statutory provisions and how those provisions have been interpreted by case law. And we're then going to offer you some top tips, I hope, as to how best to set the stage for a successful application and how best to resist applications. So I'm now going to turn over to Sophia and pop back up again shortly.
Thank you, Carol. The statutory framework governing orders for reinstatement and re-engagement is set out in sections 112 to 117 of the Employment Rights Act. And reinstatement and re-engagement orders are often described as the primary remedy for unfair dismissal. So the tribunal, if requested to make one of those orders, must first consider whether that is the appropriate course of action before going on to determine whether the issue of compensation should be determined for unfair dismissal. The power to order reinstatement is set out within section 114(1) of the Employment Rights Act. And if made, the reinstatement order will require the employer to treat the claimant in all respects as if he had not been dismissed. He's placed back into the same job with the same contractual rights on the same terms and conditions of employment from which he was dismissed. And if the claimant would have benefited from an improvement in terms and conditions, then the order for reinstatement will require that he be treated as if he had benefited from that improvement from the date that that change would have benefited him, but for the dismissal. Now, the Employment Tribunal has no power to order reinstatement in terms which alter the contractual terms on which of the claimant's former employment. And the authority for that is on the slide, it's McBride. So if, for example, there's been a restructuring following the claimant's dismissal, it's not going to be appropriate to seek reinstatement, and you should be looking at a re-employment order, a re-engagement order instead. So moving on to re-engagement orders, section 115(1) requires that if re-engagement order is made, the employer re-engage the claimant in employment comparable to that from which he was dismissed, or other suitable employment on such terms as the employment tribunal may decide. The order for re-engagement may involve a change in the identity of the employer, a change in the nature of the employment that the claimant goes back to, or the terms of their remuneration may change. So, for example, if you've got a trader who has been employed in the London branch of a global bank, the re-engagement order might require him to return to a role in another branch instead. What is suitable employment as regards a re-engagement order has to be looked at in respect of the whole job. So you have to not only consider the tasks which the job holder will be required to perform in that role, but also the terms of that employment, so especially wages and hours of work. And you also have to look at the responsibility and status involved in that job to see whether it is suitable. That's set out in Bird and Stoke-on-Trent Primary Care Trust. You've also got to look at the claimant's skills, aptitudes and experience vis-a-vis that role which is suggested to be a suitable alternative. We've also set out the case of Littleton as authority for the proposition that the claimant can't turn up to the remedies hearing and make a general pitch for re-engagement in a suitable or comparable role. They have to actually specify an available role that they've identified for the re-engagement order to be made. As Carol's already set out in her introduction, if the application for re-engagement or reinstatement succeeds, then the claimant gets both employment and an order for back pay. And the order is that the respondent pay to the claimant any benefit, including arrears of pay, that they might reasonably have been expected to receive between the date of termination and the date that the order for reinstatement or re-engagement comes into effect. Save that the tribunal must take into account and reduce the respondent's liability where there have been any wages paid by the employer in lieu of notice or by way of ex gratia payments, or any wages that they've received from alternative employment, or where they've received such other benefits as the employment tribunal thinks are appropriate in the circumstances to be taken into account. But there's no cap, importantly, on the order for back pay. So it's likely that in the case of a high earning individual, the award under these provisions is going to dwarf the statutory cap significantly, especially in a situation where that individual hasn't been employed since the date of their dismissal and up until the remedies hearing, which could be several years given the current backlog in the employment tribunals. The consequences of failing to comply with an order for reinstatement or re-engagement are set out in section 117 of ERA. So unless the respondent can satisfy the tribunal that it wasn't practicable to comply with the order for reinstatement or re-engagement, then the tribunal will order both an award of compensation for unfair dismissal, which may exceed the statutory cap to the extent necessary to enable the award to fully reflect the amount specified as payable, and an additional award of between 26 and 52 weeks pay capped at the statutory rate. So the first of those bullet points, an award of compensation for unfair dismissal, that essentially means that the claimant gets the back pay that they would have received had the respondent complied with the reinstatement or re-engagement order. Then they get this additional award. It's important to note, however, though, that section 117 sets out the complete remedies for non-compliance. So there's no power in addition to that the tribunal has to, for example, injunct the employer to comply with the order, or they can't award further ongoing loss to the claimant, for example. What's set out in 117 is the limit of their powers in respect of penalties. The choice of order and its terms. So the employment tribunal will only consider reinstatement if the claimant wishes to be reinstated. If they express that wish, then the tribunal needs to go on to consider whether it would be practicable to make that order, for the employer to comply with that order, and whether the claimant caused or contributed to his dismissal, and if so, whether it would be just to order reinstatement in those circumstances. And in terms of re-engagement, again, the tribunal will look at whether the claimant wishes to be re-engaged, and then go on, if they do, to consider practicability for the employer in complying with the order, and whether the claimant caused or contributed to some extent to his dismissal, and in those circumstances, whether it would be just to order re-engagement, and if so, on what terms. The last bullet point on the slide sets out section 116, subsection 4, except in a case where the employment tribunal takes into account contributory fault under 116(3)(c. It shall, if it orders re-engagement, do so on terms which are, so far as is reasonably practicable, as favourable as an order for reinstatement. So the employment tribunal has a discretion with a re-engagement order that it doesn't have with a reinstatement order, and that discretion is to reduce the award of back pay to reflect the element of contribution on the claimant's part to their dismissal. But as I say, they don't have that discretion in respect of reinstatement orders. So an important difference there. So the issue of practicability is going to be very important in respect of reinstatement and re-engagement orders. And practicability of the employer to comply with the order is determined as at the date the re-engagement or reinstatement order would take effect. And that's likely to be the date of the remedy hearing. Practicability, that's not a concept that's defined within ERA in the statutory framework, but it's been held to mean something that's more than merely possible. It has to be that the order is capable of being carried into effect with success. And the question is not a hypothetical one. The tribunal has to consider whether it's practicable for this employer to employ this employee pursuant to the order. Practicability is a question of fact, so it's going to be difficult to overturn on appeal. But while the tribunal should carefully scrutinise the reasons given by the employer as to why it wouldn't be practicable to re-employ the individual, they have to give due weight to the employer's commercial judgment. They can't substitute their own view of the commercial situation for that of the employer's. On the other hand, however, the tribunal must, as I say, scrutinise the reason and be satisfied that it is more than a matter of commercial preference, and what they're being told by the employer is a matter of sound commercial judgment or rationale. As you'll have gathered from the previous slides, practicability comes in at 2 points in terms of re-employment orders. So it's determined firstly when the tribunal is asked to consider whether to make an order for re-engagement. And as we said here, that's a provisional determination insofar as the tribunals might have to reconsider that or on the second occasion if the employer fails to comply with the order for reinstatement or re-engagement. So they look at practicability in the first instance when deciding whether to make the order, and then they may have to consider it again if the employer fails to comply, and they're looking at penalties, which will only be ordered if the employer doesn't satisfy them that it wasn't practicable to comply with the order. There is very little that limits the factors the employment tribunal can take into account as regards its assessment of practicability. The only express limitation when determining practicability is that set out in 116, 5 and 6 of ERA. And those two provisions read together state that the employment tribunal will take no account of the fact that the respondent has engaged a permanent replacement for the dismissed claimant unless the respondent can show that either it was not practicable for the respondent to arrange for the dismissed claimant's work to be done without engaging a permanent replacement, or the respondent engaged the permanent replacement after a lapse of a reasonable period without having heard from the claimant that he wished to be reinstated or re-engaged, and at the time of engagement it was no longer reasonable for the respondent to arrange for the claimant's work to be done except by a permanent replacement. What does a permanent replacement mean? It may be that that term is broad enough to encompass a situation where the claimant's role after their dismissal has been divided amongst a number of existing staff, and that was considered by the Court of Appeal in Kelly and PGA. However, that wasn't conclusively determined in that case. It might be that that is a situation which is encompassed within the term permanent replacement, but the matter is still open for argument. But it's important to note that there is no statutory restraint on the employer's right to fill vacancies other than that arising in consequence of the claimant's dismissal. So there's no statutory restraint or qualification that meant that in the Kelly case, the respondent had to disclose any vacancy arising between the date of the claimant's dismissal and the date of the remedy hearing. It only had to disclose vacancies for roles identified by the claimant and as comparable and suitable. I'm now going to hand back to Carol to carry on discussing practicability.
Thank you, Sophia. Just one other interesting point, and I use that term loosely, on section 1165 and section 116. The question is whether or not a reasonable period of time has passed and the time has effectively come that the respondent is entitled to recruit a permanent replacement for the dismissed claimant. And I think that rather begs the question at the moment is what is a reasonable period of time in circumstances in which it can take a year or two for a case to come to hearing. And of course, if it's a claimant, the claimant is going to want to attempt to argue that a reasonable period is in effect the time it takes for the case to be heard and concluded on the basis that the employer is on notice, in effect, that the claimant is seeking reinstatement or re-engagement. Of course, on the other hand, the respondent is going to want to explain in its evidence why it can't put its business on hold indefinitely at based on the vagaries of the tribunal system, or indeed it can't put its business on hold beyond a certain point. So I just want to turn now to look at some of the relevant factors that the court is likely to consider when it comes to determining the question of practicability. And it's, of course, important to remember that each case is going to turn on its own facts, and it's really going to be for the tribunal to assess the evidence before it and to determine what weight to afford each factors. But one of the factors that is likely to be relevant to take into account is whether there is, in fact, any suitable alternative vacancy, because there is no obligation on the respondent, either in the statute itself or as analysed by case law, to create a vacancy that doesn't exist. Nor is the respondent required to dismiss another employee to make space for the claimant. It's worth, however, having a look at the United States Navy and Cody case, where the EAT, albeit with some reservation, upheld the tribunal's finding that it was practicable to reinstate the claimant who had been made redundant, but to all intents and purposes replaced post-dismissal. And the replacement meant that there was no space for the claimant. However, the tribunal at the liability stage had found that the claimant's role hadn't in fact been genuinely redundant, but rather the respondent had wanted another employee to undertake the claimant's role, believing the claimant to be a poor performer. And at the remedy stage, the tribunal considered that the respondent's overmanning argument wasn't a good one in circumstances where it was the respondent's own mismanagement of the situation that had led to overmanning. And on the tribunal's facts as found by the tribunal, it may have been inexpedient to reinstate the claimant, but on the facts it wasn't impracticable. Another relevant factor is if the claimant considers himself to have been a victim of a conspiracy by his employer, or he asserts a belief that senior management is out to get him. That is, again, another relevant factor to point against a successful working relationship being reinstated or reinvigorated if the claimant is reinstated or re-engaged. Similarly, it will be a relevant factor if the atmosphere in the workplace has been poisoned or that the claimant has demonstrated in the way in which he makes his allegations or conducts his litigation that he in fact lacks trust and confidence in the employer, which means he's not going to be a satisfactory employee on re-employment. For example, the claimant may have given evidence at the liability stage, making clear that he distrusts his line manager, or perhaps other members of senior management. He's made allegations that they lack honesty and integrity, or have acted themselves in breach of their FCA obligations, or perhaps more general allegations have been made against the compliance group as a whole, or members of the legal department, or HR. The more that the claimant is going to be required to interact with those individuals against whom he's made allegations going forward, and the more serious the allegations made by the claimant, the less likely it is that it's going to be practicable to return the claimant to the workplace. As we all know, it's not uncommon for a dismissed senior executive to throw the kitchen sink in and to bring a whole myriad of claims on dismissal. And the fact that the claimant's unfair dismissal claim was not a standalone claim, but was accompanied by significant various claims of discrimination under all sorts of heads and protected disclosures, the fact that they were made and not made out on the evidence may mean that reinstatement and re-engagement would not be practicable. The mere fact, however, that the additional claims have been brought is not going to be enough to stop the order being made. There must be something about the substance of the allegations made or the way in which they were litigated, which means that it can properly be said that the relationship, the working relationship, has been irreparably soured. For example, it may be based on the allegations that have been made and the way in which the litigation is conducted. Perhaps there have been endless amendments to the particulars of claim each time there's been something the claimant doesn't like. And it may enable the respondent to argue that the claimant is capable only of viewing what happens through the prism of his the prism of his belief that he's been discriminated against or subjected to detriments for having made protected disclosures, and that renders him unmanageable, because arguably no manager should be put in a position where it's inevitable that claims of victimization will follow from attempts to manage a claimant. It's also relevant to consider whether the respondent continues to believe that the claimant was genuinely guilty of the conduct for which he was dismissed. That in itself may render reinstatement or re-engagement impossible or impracticable, and that's so even if the tribunal has concluded at the liability stage that the respondent's belief in the misconduct was unreasonable. Now, that really brings me on to the Kelly and PGA European Tour case. Both the EAT and the Court of Appeal decisions, which are there aren't that many authorities that really deal with reinstatement or re-engagement because the orders are so infrequently made. But Kelly and PGA European Tours is a good one, and I'd commend the EAT and Court of Appeal decision to you. It's well worth reading in those quiet winter nights. But anyway, I digress. In Kelly, the EAT considered the approach to be taken by tribunals when considering the question of practicability in circumstances where it's alleged that the necessary mutual obligation of trust and confidence is lacking. And the EAT approved and applied the guidance given by Mrs. Justice Eadie in the Farron case, which was to the effect that where there a breakdown of trust and confidence is relied upon by the employer cannot merely assert that in a self-serving way. Rather, the tribunal has to be satisfied that the employer genuinely believes that trust and confidence has broken down and cannot be repaired, and that the belief is rational. And that same test applies if the source of the employer's belief is that the employee lacks capability or his performance was poor. Again, it's a question of, is there a genuine belief, and is the belief rational? And it's important to note that it's a question of rationality. It's not a question of reasonableness. And that was made clear by both the EAT and the Court of Appeal, who stressed that it's not to be equated with the test applied under section 98.4 of the ERA. And Lord Justice Underhill noted in the EAT that when considering practicability, it's essential to recognise that the employment relationship has got to work in human terms. And that's why, as Sophia mentioned, the tribunal has to assess the question from the point of view of the particular employer and the particular employee before it. It isn't a case of the tribunal deciding that what is reasonable, or for them to substitute their own view for that of the respondent. Kelly is also authority for the proposition that it will not be practicable for a respondent to comply with an order for re-engagement where the claimant does not meet one of the essential criteria of the job. And also its authority for the proposition that the tribunal is obliged to reach decisions at the remedy stage that are consistent with the facts found by it at the liability stage, unless there are good and cogent reasons for departing from its findings of fact. And indeed, sadly, with some tribunals, you really need to remind them of what they found first time round. So, how to set the stage for a successful application? Make clear from the outset that an application is going to be made for reinstatement or re-engagement. I had a case recently, as indeed someone in this room, where the claimant brought claims for ordinary unfair dismissal, automatically unfair dismissal for protected disclosures. There were claims of direct discrimination. There were claims for victimization and protected disclosure detriments. And the case took a couple of years to come for a hearing. It was only 1 month after judgment, when all claims other than the ordinary unfair dismissal claim had been dismissed, that the claimant said, actually, I don't really only want compensation anymore. I'd now quite like to be reinstated or re-engaged, albeit at the same time, the claimant applied for reconsideration of the tribunal judgment and then, for good measure, popped in a notice of appeal, which, of course, unsurprisingly, led to an argument that the claimant's change of position was not genuine, but little more than a disingenuous attempt to circumvent the statutory cap. And that's not a great background against which you want to be persuading a tribunal that there is a working relationship to be created. It's all too easy for a claimant to allege that he has been the victim of a conspiracy or some sort of clandestine plan on the part of the employer. For example, in financial services cases, you often have a claimant saying, well, I was made the scapegoat because my employer was seeking to hide from the regulator its own regulatory failings. And it's particularly the case in whistleblowing and discrimination cases where there is an argument that the dismissal was based on tainted information. Allegations, as I said before, which are not upheld at the liability stage, may be relied on by the respondent at the remedy stage to demonstrate that the claimant lacks trust and confidence in the respondent. So I think it's important as a claimant to really be careful with the allegations that you make and avoid hyperbole or exaggeration, not least because it's also going to weaken your negotiating hand with the respondent if the respondent views the prospects of reinstatement or re-engagement as so unlikely as to be not worth considering. And by the same token, remember that allegations of lack of honesty and lack of integrity that are made against regulated individuals are very serious and should not be made lightly. And such allegations may well lead to a senior manager at the remedy stage stating that I can't possibly work with this person who in a public forum has made serious and potentially career-ending allegations against me, which have been not upheld by the tribunal. So it's worth avoiding the scattergun approach as a claimant and make sure that the individuals that you do make against allegations are, against individuals are limited and carefully reasoned. But it's not to say that a claimant should refrain from making allegations against individuals, or that a claimant will never obtain a reinstatement or re-engagement order if he believes himself to have been a victim of a conspiracy. It's ultimately going to be a matter of fact and degree. And if such allegations have been made, even if they've not been upheld at the liability stage, it's important for the claimant to explain in his remedy evidence why he believed that the allegations that he made had foundation, but probably more importantly, why he's been able to reflect and move on and consider the matter differently. Which in many cases can be quite hard for the claimant to actually convincingly do, but it really is important if the claimant wishes to be reinstated or re-engaged. And a particularly relevant matter to consider is whether the claimant would be working with different people if re-engaged. And that may well be the case because senior managers may have left or other people moved on, or indeed the claimant may be seeking a re-engagement role in an associated branch of a bank in a different country. And then it's very difficult for a respondent to say, well, people you've never met before and never worked with have no trust and confidence in you. So what about from the respondent's perspective? I think it is worth reminding the tribunal at some point that there is no rule for high earners that means they ought to be treated differently from the average claimant, despite the fact that the statutory cap for compensation doesn't go anywhere near compensating them for their loss. Financial services employees are not in a special category. And the fact that the loss may be substantial, or that the individual finds himself effectively unemployable by virtue of his dismissal, ought not, I think, in and of itself, to be a reason for reinstatement or re-engagement. If the respondent is going to be relying on some sort of trust and confidence argument, and as Lord Justice Underhill said, we want to be careful about putting a gloss on what that means or applying it from other contexts. It really means, is this going to be a workable situation if the claimant is reinstated or re-engaged, or does the respondent genuinely have no belief that this individual is going to be a successful employee? If that is the argument, it must be set out in witness statements in clear and reasoned terms by individuals who are capable of saying in terms, I do not trust the claimant, or I do not have confidence in his abilities, because sweeping generalizations aren't going to cut it. Similarly, if there remains a genuine belief in the misconduct for which the claimant was dismissed, it's important to explain that belief in the witness statements and the basis for it, and why it is so serious as to render reinstatement or re-engagement impracticable. And if there's a belief that the claimant lacks capability to be re-engaged into a particular role, again, the witness statement will also need to explain the belief and the basis for it so that it can be tested. Consider the extent to which the claimant is going to have to come into contact with people against whom he made serious allegations of conspiracy or regulatory breaches, and explain how such contact would be unavoidable. For example, the claimant may have made allegations against the compliance department, and the bank will say, well, you know, that's compliance is at the heart of what we do. It is simply untenable to say that it's practicable to re-engage or reinstate somebody who believes that the compliance department is run by people or staffed by people who mislead the regulator. So explain how the claimant is likely to interact with the department and why there is no trust and confidence between the claimant and those who work within it. Bear in mind, too, that if a regulated individual has been dismissed, the bank may well not have carried out an assessment of fitness and propriety because there was no need to do it once the individual was dismissed. However, if the individual is coming back, the bank would need to carry out an assessment of fitness and propriety. And if the reality is the respondent would say we could not assess this individual as fit and proper to carry out the role into which he seeks to be reinstated or re-engaged, then that again must be explained and detailed in the witness statement. In relation to any re-engagement role, do call the hiring manager to explain why the role is not suitable for the claimant. There have been a couple of high-value reinstatement and re-engagement orders made. In fact, they were both re-engagement orders, the JP Morgan case recently and the Fotheringham and Barclays. And in both cases, re-engagement was ordered in part because hiring managers weren't called and the respondent didn't have enough evidence to satisfy the tribunal that re-engagement would not be practicable and that the claimant couldn't properly do the role into which he was seeking re-engagement. And also, certainly in the Fotheringham and Barclays case, which is on the slide when Sophia was looking at section 117, the respondent called two senior managers who said, well, actually, I have no reason not to trust the claimant, which is fairly fatal to the application, albeit they weren't managers involved in the underlying allegations at the liability stage. Anticipate as a respondent that the claimant is likely to say in relation to any re-engagement role, I can't do it now, but with a reasonable period of training, I will be able to do it. Indeed, that was one of the arguments that Mr. Kelly tried to run in the PGA European case. He was seeking re-engagement into a role which required him to speak Mandarin. And he said, well, I can't speak it at the moment, but I am a cunning linguist and I will be able to speak it with a bit of support. The tribunal said, sounds perfectly reasonable, and granted the re-engagement order, and the EAT and Court of Appeal both disagreed, albeit in the EAT they said actually he misses the essential requirement of the role. The Court of Appeal said he's just not suitable. It's not a practical task. But the point is, as a respondent, consider, look, is training feasible? How am I going to say that it's not feasible at all, or that the period of training required is going to be so long that it is completely unreasonable? And one way to do it may be to consider who occupied the role and perhaps draw comparisons between that individual, say, who may have 12.5 years of experience in credit structuring, and a claimant who had studied it at university but's never actually done a credit structuring role because they were a precious metals trader, perhaps, for example. And you really want to show that the claimant's experience and skills are a world away from what is required. And where a claimant has been permanently replaced post-dismissal, explain when and in what circumstances the replacement was recruited, and explain why it wasn't reasonable to have filled the role on a temporary basis for any longer. And just the final point I want to mention is the case of Fotheringham and Barclays Services Limited. As I said, Sophia mentioned the EAT decision, which was on a very discrete point as to whether or not the compensate or the remedies for non-compliance with the order are confined to section 117 of the ERA or whether they're broader than that. And the EAT said it's limited to the additional compensation set out in section 117. You can't go off and get a longer period of loss, for example, or an injunction. But the first instance decision is interesting because the tribunal said that we note that we can only re-engage to a specific role and can't make a general order. But the employment judge Brown, went on to suggest that a tribunal would look very unkindly on a respondent who cynically filled all vacancies prior to remedy hearing. As I said before, the authorities suggest you're not compelled to create a vacancy. But Employment Judge Brown was the respondent, was concerned that you could get a respondent who said, well, let's just fill every conceivable vacancy we have before the remedy hearing so the claimant can't go for one. It's interesting, and one can see why that is something that's a bit unappetizing for a tribunal. But there isn't actually anything in the statute which says that an employer can't do it. And indeed, there's nothing really in the authorities which says that an employer can't do that. And indeed, the EAT recognized in Kelly that that might well just be a consequence that all vacancies are filled before one gets to the remedy hearing. I do think it's worth, however, if you're acting for a respondent, that where there have been vacancies that have been identified as suitable by the claimant, but then which are filled or put on hold for budgetary reasons prior to the remedy hearing, it's probably sensible to explain why and how that came into being, just so you don't look like the cynical respondent who's trying to shaft the claimant who the tribunal has already found has been unfairly dismissed. And it's also worth bearing in mind that if the respondent does cynically put all vacancies on hold prior to the remedy hearing, then succeeds in avoiding an order at the remedy stage and thereafter reinstates all those vacancies, you're likely to be met by an application from the claimant for a reconsideration in the interests of justice. So do be a little bit careful about that.